805.19?
Yes, sir.
All right. All right. Court will grant judgment in that amount plus interest at the statutory rate from that date until paid, plus court cost. And we'll see, was there an entry submitted with this? Yes, there was. Okay. Yeah. And I'll make, the only change I'm going to make is I grant interest at the statutory rate once his reduced to judgment and not the original rate. All right. Anything further, counsel?
No, that's it, Josh. Thank you.
All right. Thank you. Richard Scowden. Okay. All right, this is case number 23, CR 194, State of Ohio versus Richard A. Scowden. This is a hearing, final pretrial being conducted by Zoom. Mr. Scowden is appearing from the probation office. His attorney is Catherine Hapner, appearing from her office. And then appearing on behalf of the state from the prosecutor's office is Adam King. Mr. Scowden is charged, let's see here, it looks like in counts, oh, here it is, count 25 and 26. Trafficking and possession of hashish in liquid form. And count 25, that's in the vicinity of the school zone, and count 26, it's not. First degree and second degree felonies. Now, I've been presented with a plea of guilty form, which indicates that the defendant's going to plead guilty to an amended charge of count 26. First of all, Ms. Hapner, are you and your client both in agreement that the hearing can be conducted remotely by Zoom rather than an in-person appearance in the courtroom?
Yes, Your Honor, we're fine with that.
And you're all right with that, Mr. Scowden?
Yes.
All right. Now, if you should need to talk with Ms. Hapner during the hearing or ask her some questions or whatever, since you're not here in the courtroom, tell me, and I will put you and her into a breakout room, and it'll be just the two of you on the screen talking, and nobody else will be able to see you or hear you, okay?
Okay.
All right. All right. Now, the agreement says you're going to plead guilty to amended count 26, possession of hashish liquid form 2925.11 F3. I'm going to hold that up to the camera and ask you if you recognize that first page of this agreement I've just mentioned.
Yes.
On page 3, there's a signature line. Well, right below, right above the signature line, there's a sentence that reads, "I enter this plea voluntarily." About halfway back, halfway down on the last page, and it appears to be an R and then S and then kind of a squiggle. And I'll hold out the camera and ask you if that is your signature there.
Yes.
When did you sign this document, Mr. Scowden?
About noon today.
All right, and when you signed it, did you understand that it's an agreement to plead guilty, which means that there won't be a trial, and the next step in your case would be a sentencing?
Yes.
Now, did you go over this with your attorney and have her explain it to you and answer any questions before you signed it?
Yes.
And do you think you had enough time to fully consider the matter before making this decision?
Yes.
Had you been discussing the possibility of entering into a plea agreement before she presented this to you?
No, I was not talking to anybody about one beforehand.
Okay, so.
Oh, wait. Richard, you and I talked about it, though. Yeah, me and you did, yes.
Yeah, that's what I meant. Yeah, you and your attorney. What I'm getting at, I just want to make sure this just wasn't dropped on you at the last moment where you didn't have time to think about it. And that's what you've been talking with her about it before you got the agreement.
Yes, my employer's gonna let me come back to work effective immediately as long as I get this handled.
All right, okay, good. All right, now, did you enter into this agreement voluntarily, Mr. Scowden?
Yes,
And you're going forward here now voluntarily?
yes,
All right, now, as I indicated earlier, on the first page, it says that this is a third-degree felony. Currently, you're charging count one with a first-degree felony, which carries 3 to 11 years as ordered by the judge, with the possibility of any sentence being extended by 1/2. And then on count two, that's a second-degree felony, which goes 2 to 8 years, plus an additional 50%. But that one, I believe, is a mandatory term. Now, what the agreement says is that they're going to amend the 26th count of the indictment as to the, I assume you're going to do that as to the amount involved, Mr. Okay, I'm looking here at the agreement, Mr. King, you're reducing that to 50 to 200 grams.
Yes, Your Honor.
All right. So what that does, Mr. Scowden, then it takes it down from a second-degree felony, which is a mandatory prison term, to a third-degree felony, which carries a possible prison term of between 9 and 36 months in certain levels in the statute. It goes 9 and then 12 and then 18 months and then every 6 months up to 36 months. You fine at $10,000 and there's a possible license suspension of 6 months to 5 years. And although the legislature in enacting the law has indicated that it is presumed necessary that a prison term be imposed, it's not mandatory, it's still up to the court. So that's the big difference between that level of felony and the one that you're facing now in count 26. Do you understand that?
yes,
And are you facing any felony charges anywhere else?
no,
Are you currently on community control, probation, parole, or post-release control for a felony?
no,
Now, in the event you should ever be sentenced to prison for this offense, Mr. Scowden, the law provides that upon completion of that sentence, the adult parole authority has the option, if they choose to do so, to put you under post-release control supervision for a period of up to 2 years. What that means is that you'll be supervised under the terms they set by a parole officer. And if during the period of time you're being supervised, they determine that you've not complied, then they can return you to prison, even though you served the entire term that was ordered by the court, for up to 9 months for any single violation. But there is a cap or limit of half of whatever prison term was imposed for all violations. Now, if you commit a new felony offense while under post-release control, then in addition, whatever sentence could be imposed by the judge in the new case, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that has to be served consecutively sentenced in the new case. Do you understand that?
yes,
Now, under the law, as I indicated, I'm not required to put you in prison for this offense if you plead guilty. I can impose community control or probation, and that means that instead of going to prison, you'll be put under supervision of an officer, probation officer, for up to 5 years by terms set by the court. Now, if during that period of time the probation department felt that you were not complying, they will file a written notice of that with the court. There would be a hearing at which you would have the right to have an attorney, and if the outcome of that hearing was that you had failed to comply, at that time you could be sentenced to 36 months incarceration and fined $10,000. And if the cause of your being violated and terminated was a new felony offense committed during that time, then in addition to the sentence in this case, if you received a prison term in the new case, that could be ordered to be served consecutively to this one and vice versa. You understand that?
yes,
All right, now, the charge in count 26 currently reads that on or about May 19, 2022 in Highland County, Ohio, Justin Kyle Anderson, Travis James Zuber, Bridget M. Brooks, Aubrey G. Utley, and you did knowingly obtain, possess, or use a Schedule I controlled substance, hashish in liquid form, an amount equal to or exceeding 400 grams, of violation 2925.11. So that's the current status as charged. Now, what the amendment is that instead of saying that it's over 400 grams, it's being reduced to, that amount is being changed to equal to or exceeding 50 grams, but less than 200 grams. That's the amendment to the charge. Now, do you understand what that charge is, what the state said you did, and when, where, and how they allege that you did it as amended? I talked over you. Was your
Oh,
name?
my bad. Yes, I understand.
Okay. Now, have you discussed the nature of the charge, the evidence in the case, the legal issues in the case, possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with her advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs that would affect your ability to understand what's going on?
No.
Have any threats been made to make you plead guilty?
No.
Now, at the bottom of page 2, there are several lines printed in bold and underlined that read as follows. Defendant shall enter a plea of guilty to count 26 as amended to a felony of third degree by amending the weight of hashish in liquid form to an amount equal to or exceeding 50 grams but less than 200 grams. State will dismiss count 25. State and defense jointly recommend community control and substance abuse treatment. And the defendant agrees to cooperate fully with the task force. Defendant agrees to cooperate fully in the prosecution of all co-defendants. Do you understand that?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Now, under the law, the matter of the recommendation of sentence is not binding on the court. And so even though both of you are agreeing that you should get probation or community control instead of going to prison, I'm not required to follow that. So if I hear information that the sentencing hearing that makes me decide that that's not the correct sentence, I could impose a sentence of prison between 9 and 36 months in the increments provided by law. I could impose a fine. I could also suspend your license for 6 months to 5 years. Do you understand that?
Yes.
Now, do you own any license or certification from any state governmental agency that regulates any occupation or profession in Ohio?
I'm AWS certified in welding, so
Okay, well, that's a private entity, though, or a trade organization, but I'm talking about a governmental agency where you'd have to have a license to actually work.
No.
Okay. Now, you have constitutional rights you must understand before I can accept a plea from you in this matter, of guilty, that is. And that, first of all, you do have counsel, right to counsel, and I appointed Ms. Hapner to represent you. Now, her appointment wasn't simply to see if the case could be worked out, but to provide any defense that may be available to you under the law that you would like her to provide. So, if you decide that you don't want to plead guilty, that you want to defend against the charge, she'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes.
Under the Constitution, Mr. Scowden, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence would be presented. They would be instructed on the law by the judge, and then that jury of 12 would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes.
Under the Constitution, you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means is that the witnesses against you have to come into court, testify in front of you, your attorney, and anyone else who may be present. After the prosecutor's done asking questions, your attorney asks questions, that's cross-examination. And that's the purpose of that, is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena. And that forces those people to come to court to be available to testify if you want them to, even though they don't want to be present. And that is the same way that state's witnesses are forced to come in and testify against you. Do you understand that?
Yes.
All right, now under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including the trial. So no one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to comment about it, except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
All right, now under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means, excuse me, what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all at trial to defend yourself. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond reasonable doubt of every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Originally, you entered a plea of not guilty, Mr. Scowden. That plea denied the allegation in the indictment, denied you committed any crime, and exercised all the rights I've just described. If you change your plea from not guilty to guilty on the amended count 26, that plea is the opposite of the not guilty plea. The guilty plea admits the allegation as to the charge as amended, admits that they're a crime, that you committed that crime. And that plea waives or gives up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you and cross-examine through your attorney, would waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state, would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, that's what you used to find you guilty, would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentence and entry being filed. And finally, if you plead guilty, I could sentence you immediately. Do you understand all of that?
Yes.
And are you a U.S. citizen, Mr. Scowden?
Yes.
Now, do you have any questions about the amended charge or the penalties?
No.
Do you understand them?
Yes.
Have any questions about the plea agreement?
No.
You understand?
Yes.
And again, you understand the recommendation on sentencing is not binding on the court.
Yes.
You have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No.
You understand?
Yes.
Is there anything you need to speak with Ms. Hapner about before we go any further?
No.
Have any questions about anything I've explained to you?
No.
Then is it your decision to withdraw your not guilty plea and plead guilty to the amended charge, count 26, as we've described in this plea agreement?
Yes.
Then as to the amended charge, which reads that on or about May 19, 2022 in Highland County, Ohio, that Justin Kyle Anderson, Travis James Zuber, Bridget M. Brooks, Aubrey G. Utley, and you did knowingly obtain, possess, or use a Schedule II controlled substance with hashish in liquid form, an amount equal to or exceeding 50 grams, but less than 200 grams, in violation of Section 2925.11 of the Ohio Revised Code, a third-degree felony carrying the penalties I've described to you previously. How do you plead?
Guilty.
All right. I'm going to go ahead and write in for the record. I'm going to note that I'm writing in that deleting the 400 and putting 50, and then put in and not exceeding 200 grams. And I've just written that on the indictment, count 26. All right, the court finds that on this date in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted and order filed. He's found guilty of the amended charge as set forth in the plea agreement. Count 25 is dismissed. The court will order a pre-sentence investigation, which shall include an assessment for mental health and/or substance use disorder issues and treatment. Bond will be continued. We will set the sentencing hearing for March the 13th at 8:30 a.m. So you'll need to see the probation department to make your appointment for your pre-sentence interview so they can have that report for me.
Okay, can you just repeat the time and date for that?
Yes, it's March 13 at 8:30 in the morning.
Okay.
Okay, that's a Wednesday.
All right.
All right, and check with probation then, and they'll keep you informed as well. And stay in touch with your attorney.
All right.
All right, thank you. All right, we're back on record on State versus Alan L. Reynoso, on a Zoom hearing.
It's muted.
Pardon me? Oh, okay. Yeah, we're back on record. Mr. King's now in the courtroom since we have another hearing here in person. Ms. Hapner is still on the Zoom hearing. Mr. Reynoso has not appeared at the court, not appeared at the probation office. I assume you haven't heard from him, Ms. Hapner?
I tried calling him again while we were waiting, and it got the voicemail again.
All right. Well, we've had repeated problems with Mr. Reynoso. That's one of the reasons, that's one of the reasons I had ordered him to appear in person. And since he's not doing so, even though it appears there's an agreement worked out, the defendant seems to think that his appearance is as he is able or willing to be present, and in order to disabuse him of that notion, the court will order capias to issue for his arrest and put the case on the inactive docket. And once he's taken into custody, we will set the matter for hearing. If he contacts you, Ms. Hapner, tell him to turn himself in.
I will do so.
All right, thank you.
Thank you.
Yeah. All right, go on record on Jemison. This is case number 23CR229, State of Ohio versus Joseph Lawrence Jemison. This was a hearing set on the application filed by the treatment facility for involuntary medication to be administered to the defendant as part of his treatment to restore him to competency. Now let's see. Ms. Short, I see you're on. Are you with the Twin Valley? Oh, you're the treating psychiatrist, I see. Okay,
Yes,
Dr. Short. All right. Now, is the defendant available on screen?
No, Your Honor, he's refusing to attend the hearing.
Okay, for the record, this is Marla Yoder, is that? Yeah, Yoder. I'm looking through my bifocals, all right. And you are, ma'am?
I'm a social worker here.
Can you activate your video?
I'm trying to, Your Honor.
Oh, okay.
I'm having trouble. I had trouble at an earlier hearing as well this morning.
Okay.
I'm not sure what's going on.
Well, that's all right. And your position, ma'am, is what?
I'm sorry?
What is your position?
I am a licensed independent social worker. I work at the hospital.
All right. Okay. All right. Well, we'll go ahead and then proceed. Mr. Jemison's attorney is Jacob Wagner. This is a Zoom hearing being conducted since there's an expedited requirement that the hearing be held on this application, and we didn't think we would be able to get Mr. Jemison back in time. Ms. Collins is appearing on behalf of the state. Now, this charge involved assault on a peace officer, and there is an expedited requirement for hearing to be held within 5 days of the petition being filed. So the court went ahead and scheduled this as soon as it received the email. Although the application itself didn't get filed until this, today. It was placed by mistake into the sealed medical records. Now, Ms. Collins, based on that, did you have the opportunity to attempt to contact the alleged victim of the offense?
Yes, they've been notified.
All right, okay, well, based upon the requirements of this statute, the normal 10-day notice would not be applicable, and we'll go ahead and proceed. All right. For the record then, Mr. Jemison has been reported by Ms. Yoder as refusing to attend, and the court will note that Mr. Jemison's previous conduct in the hearing has been one of difficulty, to say the least. And so the court will go ahead and proceed without him being present. Mr. Wagner, have you had an opportunity to review the application?
I reviewed the application and the applicable statute. Yes, I have, Your Honor.
All right. And Ms. Collins, do you have anything you'd like to add on behalf of the state?
And you keep freezing up. What did you just say?
Do you have anything you would like to add on behalf of the state?
I believe that I need to establish, my reading of the case law is that Ms. Short needs to be established as an expert in the questions asked.
Right, I agree. I just wanted to see if there's anything else you wanted to add before we do that.
No.
Okay, all right. Then we'll go ahead and proceed. So, Dr. Short, if you would raise your right hand to be sworn, please. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, I do.
All right, Ms. Collins, if you'd like to inquire.
Thank you. Ms. Short, could you, or Dr. Short rather, could you please talk about your background and education?
Yes, I attended the West Virginia School of Osteopathic Medicine from 2009 to 2013. I then completed psychiatry residency at The Ohio State University from 2013 to 2017. From 2015 to 2017, I was chief resident at the psychiatry residency at Ohio State University. Since that time, I have worked as an inpatient psychiatrist at Twin Valley Behavioral Health Care and Ohio State University.
And are you currently employed?
Yes,
And where are you employed?
I'm employed at Twin Valley Behavioral Health Care.
And what are your job responsibilities there?
I'm an inpatient psychiatrist, so I manage patients who have been admitted and treat their mental illness and manage their medications and their lab work and medical conditions.
And how long have you been employed in that position?
I have been employed at Twin Valley since September 2023. Prior to that, I was at Ohio State for 3 years, and prior to that, I was at Twin Valley for 3 years.
Have you been established as an expert in any court in the state of Ohio?
Yes.
At this point, we would ask the court to accept Dr. Short as an expert in
Psychiatric treatment?
Yes.
All right, Mr. Wagner, you have an objection to that?
I don't have any objection, Your Honor.
All right, you may, she's so declared, you may proceed.
Dr. Short, through your work at Twin Valley, you become familiar with the patient Joseph Jemison.
Yes, I am.
And did you prepare a report, or did you assist in preparing a report that was presented to the court regarding Mr. Jemison and his need for medication?
Yes, I did.
And do you have that report there in front of you?
No, I do not. I could pull it up.
But that's okay. Just as long as you're familiar with it and that you did help prepare that.
Yes, I did.
Okay. And you have determined that medication is necessary to restore the defendant to competency. Is that correct?
Yes.
And what medication have you determined would be necessary?
I would like to treat him with Invega, which is an antipsychotic. Our team has spoken with his mother, and she said that he has done the best on that antipsychotic in the past. That would be my preference.
Are there side effects to this medication?
There can be. It's generally a well-tolerated medication, and Mr. Jemison has not experienced side effects to this medication that I'm aware of. previously, but the most common side effect that you see with this is some muscle stiffness, which is easily treatable.
If there were side effects that would significantly interfere with his ability to assist in his own defense or something of that nature, would you discontinue the drug?
Yes, I would switch to an alternative medication.
Now, at this time, has Mr. Jemison been given the opportunity to voluntarily take this medication?
Yes, he has.
And what has been his position on that?
He's refused medications, and he said that he does not need them.
Is it your expert opinion that these drugs are in his best interests?
Yes.
Are they likely to restore him to competency?
They are likely to treat his mental illness so that he will be able to attend competency restoration groups and have a more realistic chance at achieving competency restoration. Without the medication, I do not believe he will be restored to competency.
And I believe those are all my questions. We would ask the court to take judicial notice of the application that has been filed in the court that Dr. Short participated in the preparation of.
Yeah, it's part of the court file also. That certainly I'll do that. Anything further, Mr. Collins?
No, Your Honor.
All right. Mr. Wagner, you have any questions?
I do. Ma'am, this medication that you spoke about, just to understand you correct, is this something he would have to take continuously throughout his lifetime to maintain his competency, or is this just to get him to the next step?
Yes, he would need to continually be on medication to maintain his competency.
So if he takes, so if you guys involuntarily give it to him now and then down the road he just says, I'm not taking it, we're going to be right back in the same boat. Is that a fair assessment?
I expect that would be the case.
Okay. No other questions, Your Honor.
Any further questions, Ms. Collins?
No, Your Honor.
All right. Mr. Wagner, you have any arguments you'd like to make in regards to the application?
Your Honor, my only argument being, and I've read the statute, and while I understand that it's what we're under here today, I guess the whole thing of my questioning was, we're forcing this guy to take medicine to become competent that he doesn't want to take. The moment we cut him loose, he's going to quit taking this medicine.
No, we don't normally cut him loose if they refuse medication. That's not the
Well, I'm
case.
saying, well, let's restore him to competency while he's on the medication. We get him back out, we're back on the active docket, he refuses to take the medicine, we're right back where we're at again, I guess.
Well, he can continue to be ordered. I can continue to order him to take the medication to maintain his competency. If he is restored to competency based upon the medication, I do have that authority under the statute. So I think where you're going is that if he comes back and quits taking it, we'll be right back where we are. And the answer to that question is going to be no, because I'll make sure he stays up there at the hospital pending the trial and gets his medication until the trial date.
I understand, sir.
Okay. So is there anything beyond that you'd like to argue?
Just for the record, I don't like the statute, I just have my objection to it, Your Honor.
Okay. Well, anything you would like to say in response, Ms. Collins?
Not to that argument, Your Honor.
All right. Well, while it might sound cruel or draconian to force people to take medication, this man's charged with a serious offense of violence. He has a long psychiatric history of involved in a lot of different behaviors, and so notwithstanding his objection to taking the medication, he can't have his cake and eat it too. He can't say he's incompetent and not undergo competency restoration by taking medication, and then stand on the idea that, well, because I refuse to take my medication and I can't be restored to competency without that, then I'm not going to be required to face trial. So that's not going to happen. The statute, that's why the statute's in place, protect the public as well as the alleged victims of any crime. And so therefore, it's the court's finding that the defendant could be restored to competency by administration of medication as part of the, and he was ordered to undergo treatment, and that his refusal justifies under 2945 .38B1C, the court ordering, and the court does hereby order, that Twin Valley Behavioral Health Care Treatment staff is authorized and directed to administer any medication necessary to assist in restoring him to competency to stand trial. Again, if that is necessary to be done physically, use physical means to do so, that is also ordered. All right, I'll have an entry prepared and filed it probably tomorrow. Anything further?
Thank you, Your Honor.
All right, is there anything else you need from the court other than a copy of that entry, Doctor?
No, I believe that is it. Thank you.
All right, thank you. All right, we have Mr. All right, this is case number 22 CR 33, State of Ohio versus Seth L. Eidner. You're Seth L. Eidner, appearing there from the jail?
Yes, sir.
All right, this is a Zoom hearing being conducted remotely. Mr. Eidner, as indicated, appearing from the jail. His attorney is Jacob Wagner, appearing by Zoom on his cell phone, and Mrs. Collins, the prosecutor, is appearing also by Zoom. This is a hearing on a notification of violation of alleged violation of terms of community control. And Mr. Wagner, you and your client both in agreement that this matter can be conducted by Zoom rather than in person?
Yes, sir, we are.
And you're all right with that, Mr. Eidner?
Yes, Your Honor.
All right. The defendant was placed on community control on April the 12th of 2022 on trafficking in marijuana, 5th degree felony, and aggravated trafficking in the vicinity of a juvenile, a 3rd degree felony. The court received a notification of alleged violations of community control. Let's see. That was filed on January 24th of 2024, and it alleged that the defendant violated rules 2, 11, 15, 18, and 19A. The defendant was informed of this by a magistrate, and Mr. Wagner was appointed to represent him, and the matter is before the court now for an evidentiary hearing. And Mr. Wagner, have you had an opportunity to review the allegations with your client?
We have, Your Honor. Seth does admit to the violation, waives the hearing on the allegations.
All right. Mr. Eidner, the allegation that was filed on the 24th are that you violated Rule 2 by failing to report since November 16 of last year. Rule 11, you were arrested on January 11 in Warren County on possession of controlled substance and illegal use of for possession of drug paraphernalia, failed to report that. Rule 15, that you failed to pay court restitution in monthly payments as ordered beginning July 1 of 2022. Rule 19A, you made one payment, it says. Rule 19A, that you failed to comply, provide documentation of aftercare completion. So those are the allegations. Now, if you admit to the allegations, one of 3 things can happen. I can continue community control under the same conditions previously ordered. It can continue with additional conditions I think are appropriate, including extending it to up to 5 years. And the third and the most serious is I could revoke your community control and sentence you to prison on count 2 for a period of 36 months, fine you $10,000. And I could order you to serve an additional 12 months on count 1, either concurrently with that charge in prison, or serve that in the county jail once you've completed count 2 term. Now, you're entitled to have an attorney in this matter. I'm sorry, you're entitled to have a hearing in this matter, at which the state is required to present evidence that you committed these violations, and that's why we're here. During that hearing, your attorney can cross-examine the witnesses the state presents to try to bring out evidence that might help them or help your side of the case. He also you can testify on your own behalf, although you're not required to do so. Now, in the event that, and like I said, I've explained to you what the consequences are. Now, Do you understand the allegations?
Yes, Your Honor.
You understand your right to have a hearing?
Yes, Your Honor.
Has anyone threatened you in any way to make you admit to these violations?
No. No, Your Honor.
All right. Then do you admit the allegations that were contained in the notification I just read you filed on January the 24th?
Yes, Your Honor.
All right. Okay, anything from the state probation department regarding disposition?
Thank you, Your Honor. Both the state and the probation department would request that Mr. Eidner's community control be extended for a period of a year and that he be ordered to enter and successfully complete the STAR program. I believe he has a bed date for February the 14th.
Mr. Wagner?
Your Honor, I've spoken to Seth, and should the court go along with that, Seth did admit to me that he is thinking that the STAR program would be beneficial. There's obviously substance abuse or some behavioral modification necessary in this case, Your Honor.
Anything you'd like to say, Mr. Eidner?
I want to be able to get my second chance to go to the STAR program and complete it to the best of my ability and be out to be a better father for my kids.
All right. Well, let me say this. You know, when I put you on probation the first time, that was your second chance. So this is the third chance. Now, what I'm going to do is I'm going to give you that, but there are going to be some additional conditions. First of all, I'm going to extend your community control to 5 years because we have restitution to be paid and you haven't done that, and I want to make sure that gets done. In the event that you do get that paid off and you are otherwise successful in the future, then it may be that they'll be considered to be terminated prior to that. You're required to successfully complete the STAR and program and aftercare that's recommended, and you're going to pay the court costs. You're going to remain in jail until conveyed to STAR. And I'm also going to recommend refer you to the drug court docket for possible oh no, this is a third-degree felony, so I can't do that, not third-degree trafficking. So, all right, so there won't be any referral to drug court, but STAR and aftercare. Now, Mr. Eidner, you have to successfully complete STAR. There's no credit for 80%, 90%, not even 99%. It's 100% or bust. And if you come out, if you get kicked out, other than for a legitimate medical reason that you didn't cause intentionally, such as smashing your hand into the wall in order to break your hand, something like that, which has happened, that's not an excuse. That's an unsuccessful completion because you did it on purpose to get kicked out. You have a heart attack that you didn't know was coming on, that's a different matter. But what happens, you go into treatment and then when you're done, you go back. But you have to successfully complete it. And if you don't, that will be a one-way ticket to prison. That's guaranteed. All right. Do you have any questions?
No, Your Honor. Thank you.
All right. All right. Thank you.
Thank you.
Now, Mr. Breeden, has Ms. Rickman showed up there at the probation? You're on Zoom. 23 CR 206, State of Ohio versus Trinity Rickman. This matter was set to request of counsel for a hearing, and she has filed a motion for intervention in lieu of conviction that was filed last week. But I understand that she may have been over there and has left. Is that correct?
Yes, sir. She was in earlier this morning, and she left a voicemail stating that she could not find another ride over, and I was informed that she was also in contact with Mr. Wagner.
All right. So what Mr. Wagner, apparently she signed the paperwork and then left thinking that was it.
Yes, Your Honor, I called Trinity earlier in the week, tried to get a hold of her, finally got a hold of her, said come in with some questions. I don't know what her confusion was. She went to probation, signed papers for the assessment, then left, called me today, said she signed it. I'm like, no, she didn't sign the right stuff. Get back over here. That was around 11-ish maybe. And I waited in my
All right, well, since this hearing was set at your request, and there has been some contact, I'm going to give her another chance. So let's get this set sometime next week, Mr. Wagner. I have, as I've indicated yesterday, I have pretty much a full week available now other than Friday because I've changed my schedule in Columbus. So, okay.
I'll get whatever.
All right, thank you. All right, this case number 23 CR 197, State of Ohio versus James Stephen Fetro. This is a final pretrial. The state's represented by Adam King, Assistant Prosecutor. Mr. Wagner is appearing on behalf of the defendant, and are you James Stephen Fetro? All right, Mr. Fetro is charged, there's actually, I think, 6 other co-defendants. He is charged in counts 30 and 31 of the indictment with a permitting drug abuse and a forfeiture specification. I think this is set for trial on February 29. This is a final pretrial. Now, is discovery complete from both sides?
This from the state, Your Honor. We filed December 13th, Your Honor.
And there are no pretrial motions?
No, sir.
Okay. What's the situation with the written plea offer? Has it been rejected?
At this time, Your Honor, it's been relayed and, well, I would say not accepted, but that's another way of saying rejected. I'm still talking to my client about it. Ms. Collins and I are still discussing issues, but at this point, we're probably going to trial.
All right. Well, if you're going to do that, have him sign the written rejection form so that you and give a copy of it to the prosecutor so both of you have copies of it.
Yes, sir.
Mr. Fetro, the court's policy is no plea bargaining after 2 weeks prior to trial, so your jury notices are going to go out on the 15th, and that means that that's the last day that there could be a resolution of the case without trial. And once that happens, we set out jury notices, people start changing their lives, coming in, everything changes to set up for the trial. So we're not going to waste everybody's time by, I don't let people waste time like that by coming in the day of trial or a couple days before and saying, I changed my mind. So, all right. Anything further, counsel?
No, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Please rise.